Yes. Yes, start.
Okay. Good morning, everybody. I am Manoj Kumar Chaudhary, Advocate, Supreme Court of India. Welcome you all on behalf of Nani Palkiwala National Law Club. The main mission of this law club is to reach last mile of the citizen. Presently, we are running 3 programs. The Legal Camp, which provides the legal advice to anybody in India free of cost. The second program is to know the insight of the AOR exam, which is this particular program. And the third is jurisprudence of Supreme Court in last decades, where we discusses different how the case is evolving in the Supreme Court. To interact with this AOR program, we have Mr. Jayprakash Somani, Advocate, Supreme Court of India, and a director of this law club. He has written more than 60 books in the case laws of Supreme Court and 3 books especially for the AOR exam. All the books are available on the Amazon and Flipkart. So from here, over to you, sir.
Thank you. Thank you, Manoj. Manoj is practicing lawyer in Supreme Court of India. And he is associated with me. And he is a convener of this Nani Palkiwala National Club. So friends, welcome to all 5 AORs whose tricks you will get today how to crack this AOR examination. जैसे बाकी एग्जामिनेशन होते हैं ना, वैसा ही AOR का एग्जामिनेशन है, लेकिन बहुत टफ रहता है. 60% को पासिंग रहता है. 4 साल practitioner lawyer. After completing 4 years as your legal practice, then you have to join 1 year internship with any AOR in Supreme Court who have more than 10 years experience. Then you can fill the form of AOR examination. And after clearing AOR examination, then you will be advocate on record in Supreme Court. और सुप्रीम कोर्ट में एडवोकेट ऑन रिकॉर्ड का और बाकी एडवोकेट का क्या रोल है? तो एडवोकेट एंड रिकॉर्ड कैन फाइलिंग्स, कोई भी एप्लीकेशन फाइल करना है, फाइल एक सब एडवोकेट ऑन रिकॉर्ड करता है. और बाकी भारत का कोई भी लॉयर आर्ग्यू कर सकता है सुप्रीम कोर्ट में, क्योंकि हमको जो राइट टू आर्ग्यू मिला है एज पर एडवोकेट एक्ट, ये राइट टू आर्ग्यू वी कैन आर्ग्यू इन एनी कोर्ट ऑफ इंडिया इंक्लूडिंग ट्राइब्यूनल, सुप्रीम कोर्ट. इसलिए आर्ग्यू करने के लिए हमको कोई भी भारत का कोर्ट नहीं रोक सकता, लेकिन फाइलिंग के लिए रोक सकता है. इसलिए कुछ हाईकोर्ट का भी अपने अपने AOR का पैनल अलग रहता है, और कुछ सुप्रीम कोर्ट का जो है दुनिया में भी देखा है, सुप्रीम कोर्ट के पैनल अलग ही रहता है. तो यहाँ पे हमारा सुप्रीम कोर्ट में AOR का एग्जामिनेशन होता है. जैसे बॉम्बे में भी AOR सिस्टम है, लेकिन वहां पे एग्जामिनेशन नहीं होता है. एडवोकेट होने के बाद बॉम्बे हाईकोर्ट का AOR का खाली आप रजिस्ट्रेशन कर लो, यू कैन फाइल द केसेस देयर. तो ऐसा एक AOR का सिस्टम है. तो 4 years minimum practice in your legal field, then 1 year internship any more than 10 years practicing AOR in Supreme Court. That time then you can apply for this examination. And examination carries 4 different subjects. That 4 different subjects are practice and procedure of Supreme Court. It carries 100 marks and time limit for writing that paper is 3 hours. Second paper is of drafting, and drafting carries 100 marks, and out of that 3 hours writing paper, but half hour you will get for reading newspaper, reading your question paper extra. Then paper 3, professional ethics, and you will get 3 hours for writing paper, 100 marks paper. And fourth is leading cases, 64 leading cases. If you think all papers are scoring, and if you think all papers are challenging also, that it depends upon how you practice. So I will add on some things after each speaker's tricks because they have already passed. I have not passed this examination because I am an arguing counsel. In my law firm, there are 12 juniors. Out of that 12 juniors, 5 are AOR. And my books are there for AOR examination because in this age, when I joined Supreme Court after Bombay High Court practice, I was at that time 84, 54 years old. Now I'm running in 60s. So we don't want to become AOR and filing the cases in Supreme Court. So we don't become AOR. My juniors are AOR. And anybody from India can become AOR by cracking this examination, and they can shape their future, brighter future in apex courts of India. तो चलो दोस्तों, आज हम आपको बताते हैं कि जो हमारे आज 4 पार्टिसिपेंट हैं उनके मार्क्स भी बहुत अच्छे हैं और हमने पोस्ट में शेयर किए हुए हैं मार्क, ताकि आपको पता चले। एवरेज पासिंग इसका 50 मार्क्स के ऊपर रहता है, लेकिन एवरेज चारों सब्जेक्ट का मिलके 60% आना चाहिए। तो किसी में अगर 65 है और किसी में 55 है तो एवरेज हो जाएगा, ऐसा है। और कोई भी एक सब्जेक्ट में भी आप किसी एग्जामिनेशन को पास हो जाता है ना, दैट टाइम यू कैन गिव एग्जामिनेशन दैट टू सेकंड अटेम्प्ट, लेकिन पूरे सब्जेक्ट देने पड़ते हैं। लेकिन कोई बंदा अगर चारों सब्जेक्ट में पहले एग्जामिनेशन में ही फेल हो जाता है, 40 के नीचे मार्क्स आते हैं, 50 के नीचे, 40 के नीचे ऐसे मार्क्स आते हैं, तो उसको वो एग्जाम वापस देना अलाउड नहीं है, देने नहीं देता है। फिर चीफ जस्टिस ऑफ इंडिया का परमिशन लो वगैरह, ऐसे कुछ प्रोसेस है उसके लिए। बट यू हैव टू क्लियर दैट एग्जामिनेशन विद इन 4 अटेम्प्ट्स ओनली 4 अटेम्प्ट्स मिलता है। इसलिए वाइजली देना। कुछ कुछ लोग रहते हैं फर्स्ट अटेम्प्ट में क्लियर कर लेते हैं, और कुछ कुछ लोग रहते हैं 4 अटेम्प्ट में भी क्लियर नहीं कर पाते बिकॉज ऑफ देयर राइटिंग स्पीड्स। यस, नाउ सुमित कंसल, let me search so I can mute Sumit mic. Sumit, can you hear my voice? Yes. Just a minute. Ask to mute. Yes. Now you can mute yourself. Yes.
Yes. Now it's on.
Are
you able to hear my voice, Somani ji?
Yes. Just hold on a minute. मैं स्पॉटलाइट पे लेता हूं आपको, तो आप सबको दिखाई देंगे। और सुमित जी, आपको बहुत अच्छे मार्क्स मिले, मैं आपको अभिनंदन करता हूं।
Thanks
आपको
a lot, sir. Thank you so much.
यस, पेपर 1 में प्रैक्टिस एंड प्रोसीजर में 74 मार्क्स हैं, ड्राफ्टिंग में 67 मार्क्स हैं, पेपर 3 फंडा प्रोफेशनल एथिक्स में 63 मार्क्स हैं, एंड लीडिंग केसेस में 70 मार्क्स हैं। बहुत अच्छा परसेंटेज आपने निकाला है। तो लेट मी आस्क यू क्वेश्चंस, और आप क्वेश्चन को जवाब देते देते हम आपसे निकाल लेंगे जो निकालना है ऑडियंस के लिए।
I'll be most happy to help you and answer any questions.
और सबसे बड़ी बात कि हमारा जो एपेक्स कोर्ट है, सुप्रीम कोर्ट में आपका ऑथोराइज एंट्री हो गया बाय क्रैकिंग दिस एग्जामिनेशन। मैं पूरे एससीबीए की ओर से और स्कोरा की ओर से आपका वेलकम करता हूं सुप्रीम कोर्ट के लिए। और
Thank you so much.
आपको हम अलग अलग पोजीशन पे फ्यूचर में सीनियर डेजिग्नेटेड लॉयर, फ्यूचर में जज बोल के सुप्रीम कोर्ट के एज एलिवेटेड जज, ये सब देखना चाहते हैं। उसके लिए जो भी सपोर्ट लगेगा ये आप जरूर करेंगे आपको, डोंट वरी अबाउट दैट।
Thank you, sir.
अभी
Thank
मुझे
you so much.
यस मुझे ये बताइए कि थोड़ा सा आपका बैकग्राउंड क्या है?
All right, I'll just convey.
Yes.
So
Yes.
good morning everyone, and I am much thankful to Nani Palkiwala Club and Somani ji and Chaudhary ji for inviting me here, for giving my insights and guidance on the AOR examination. So by God's grace, I could clear the exam in my maiden attempt with only 20-25 days of study. So friends, I am Sumit Kansal. I am a qualified chartered accountant of 2011 for almost a dozen years now. and I am also a practicing lawyer since 2017 for over 6 years. And as you all know, have recently qualified as an AOR. So I come from Ambala, sir. I come from Ambala, Kent, is a town in Haryana. And I did my BCom honors from Shri Ram College of Commerce in 2007-2010 batch. CA again was my first attempt. I cleared both the CA inter and CA final in my maiden attempt. And then I joined law. So I am a gold medalist in law. I got 6 gold medals. And thereafter, I started almost after working for almost a year with a lawyer. I then started my own chambers. I have my practice with a firm named Kansal Law Chambers. It's a niche practice in corporate commercial tax laws. I am based out of Connaught Place in New Delhi. So I have a team of 5-6 people with me, and we work across forums, especially having practice before arbitration, NCLTs, tax tribunals, and commercial courts. So that is it about it. And now to start with, so friends, see, an exam is not an easy, I'll start with, is not an easy or a difficult exam. It depends upon your preparation, your mindset, and understand the strategy of what is required from you regarding a certain exam. AOR exam is no different. So I'll start with giving 4 or 5 pointers which I think are pertinent and which would be different from the general league of the advice and the guidance given. And then I'll just run you through, because I've been given a 10-15 minute slot, and another 5 or 7 minutes I'll run you through the question paper which we attempted in the last exam. So first point is that please understand that this exam, apart from the other 3 exams, is of 3.5 hours. That means that you get 30 minutes in the starting to read the question paper, and depending upon the examination hall or the examiners, they sometimes give you the answer sheets also in the very starting. So having said that, even though you get an additional half an hour in this exam, time is of essence, because this is a very difficult paper that you have to write in all those designated 3 hours, because writing can only be done after that half an hour. And so it's a little challenging. Now, what is the strategy here? What I did was, first, once you get those answer sheets, please mark them, please number them. Once you number your answer sheets, you understand this is the total pages, and there are generally 5 questions to attempt. This is what the past exams have shown, which are of 20 marks each. So even though there is no bar to get additional sheets in the examination hall, however, there is a bar to our writing, which can be maximum 25, 30 or 35 pages to be written in those 3 slotted hours, depending upon your speed. That is why I say that you have to balance, and you have to give 4 or 5 pages to each answer, so that you understand that this is the pages I have written, and this is the content I have written, and this is the time period in which I have written. So the total time to us is 180 minutes, in which you have 5 questions to attempt. So let us consider that you have around, if I say around 35 minutes for each answer to be written in this particular paper. Another challenge is that generally there is no choice given in this paper. So you must understand all the formats. You cannot just shrug your shoulders stating that I can skip an election petition or a criminal contempt or a transfer petition which is civil in nature. So you must number your answer sheets, and then in those 30 minutes is where the importance is. One more peculiar thing about this exam is, this paper is that it is a battle of nerves. Unlike paper 1, which is practice and procedures, that is essentially the jurisdictions before the Honorable Supreme Court, and paper 3, which is professional ethics, you have to mug up to an extent. If I could candidly say that you have to exactly mug up Article 129, Article 130, Article 141, all those Article 136, the exact language, the bare language from the bare Act of Supreme Court rules, and the Constitution of India, of course. And paper 3 also, ethics, you must know what is the rights, duties of a lawyer. However, in paper 2, you cannot mug up anything. I would be afraid to say that for a regular practitioner, this paper would be very easy. Unlike that, he practices before the Honorable Supreme Court. He might be practicing before the district court, because the formats are similar in nature. or he may be practicing before the honorable tribunals. But once he knows drafting, then it becomes very easy. You just need to know the formats. But if you are not practicing, it might be a little difficult. So what I suggest is that you practice at least 3 to 4 times in this. I think 1 month is there now before the exam comes in June. And that practice makes a difference. It is a battle of nerves. You don't mug up anything, but in those 3.5 hours is the difference. So please have proper sleep. In our time, these exams are consecutive. I think there is a holiday also in between. I'm not very sure, just check. And please take proper sleep, and please be very alert once you attempt this question paper, because there is no material to study in this paper. But how alert you are, if you see the questions might be very complex in nature, and that is where you have to apply your mind. You apply your mind to read the questions, you amalgamate, you absorb. That is the processing, step 2. And the third is act. You execute by writing it on the question paper, on the answer sheet. So I would suggest that you don't start from answer 1, depending upon your ability. You start from a mediocre kind of a question, which is mediocre in nature. Once you attempt 1 or 2 questions, you will be in the flow of things, the momentum will be maintained, and then you can take up that complex question. So meaning thereby that the 5 questions may not be evenly balanced. 2 could be complex questions, 1 could be quite easy, and 2 could be mediocre, generally speaking. So accordingly, you have to see. Another thing which I felt is that if you have that 35 minutes, you might take 5 minutes extra to write properly rather than writing more. Meaning thereby that instead of 5.5 pages, we write 4 pages or 4.5 pages, but the correct questions of law, grounds should be written. See, this is not an exam. It's not clerical in nature, or it is not rote learning that you borrow something from the question itself. The facts will be given. You know the law because you are a lawyer, but then that is where the questions of law come in place, because you know the law, and sometimes it is appendix to the questions also. In our time it was, they give the acts provisions also. But then the grounds, there is your creativity coming in. There is where you synthesize the facts with the questions of law to make up those grounds. Those cannot be merely grounds that because the Honorable High Court or the lower court erred in law, did not appreciate. You have to say why. Why was it done? You have to give a proper reason. You may not write 10 grounds, write 3 to 4, but good grounds, solid grounds with proper backup. Synthesizing the facts with the law, with your corresponding with the questions of law. So that is important. Next point is subrogation. You have to step into the shoes of the judge or the examiner. There are 40 to 50 sheets or cases listed before the honorable judge, akin to a judge. So examiner will have to, your sheet should stand out. See, this is not an exam in which after qualifying this exam, you have an interview. All right, there is no personality test. So the body language has to be shown from that answer sheet itself. How? You may carry a paper, pencil, or a scale, and you do the proper formatting. It should be legible handwriting. You must see that if the answer sheet is full, your writing should not come in between. So you must see from you cannot see here from a client's point of view or from your own point of view. You have to see from the judge's point of view what he wants you from the answer. Don't suppress any facts, but try to combat them with your arguments, if it is on the weaker side or coming from the opposite side. So you are attempting an exam for the highest constitutional court in the country. You must understand that the quality is high, and how it is achieved is by practicing, by knowing and understanding those facts. So another thing is that sometimes there is a format which is given. For example, you have the Supreme Court rules 2013, and then there is this form number 28 for an SLP, which is both for a SLP, civil appellate jurisdiction is given. So you have to write that proper format. That is important. So sometimes people make a mistake that they don't write the position of the parties properly. So that is very important. Then you also have to write the Supreme Court particular rule. For example, this is Order 21, Rule 31A, the civil appellate jurisdiction of the SLP civil, form number 28. So there is a proper format for this particular thing. Unlike a review petition in which you can have your own kind of a thing, there is no set format as such. So there are 8 parts to it, and the interim application, the interim relief is a part of this SLP civil itself. There is no separate kind of an application to this effect. Now coming to the next, I would say that you might start reading paper 4, which is your case laws, which again is a open book exam and there is no mugging up. And once you start reading a judgment, stop in between of the judgment. You understand this is the facts of the case. This is the petitioner's argument. This is the respondent's argument. And then you close that book. You make your own arguments that this should be the questions of law. These are the issues. And then you see from those judgments, because those are landmark judgments, those are decided cases, so that you will be able to understand how the drafting is done, because the judgment is already in place and it's a leading paper also. And in this way, two of your papers can get simultaneously studied. Now, the prayer is also very important, which you must understand what is the relief you are asking. So what is the requirement? Along with this, I would say when you start your para 1 of any petition or any application, you must start it with small sentences. Don't make it very complex. Sometimes the trick is that sometimes we put two arguments in one sentence or one fact and law. So that should be prohibited. You might add small sentences understandable to the examiner. See, they're not testing your English. They are not testing that very flowery language. You have to synthesize something which is very complex in a very simple, decent manner. The way we tell to a client on the factual side, we tell here to the examiner on the legal side with our legal acumen. But it has to be in simple tone. First para should set the tone, the base of what is being asked. So this is the facts of the case. This is the impugned judgment and why we are here. And we are here through this remedy. So obviously you are all lawyers. You know that SLP remedy is different, rate is different, a civil appeal is different. So this is how it is. And please segregate the chaff from the grain. The facts versus law are different. Why I say so? Generally, sometimes in questions of law, questions of fact are written. This is a court in which questions of law are asked in the constitutional courts, in the High Court and the Supreme Court. Don't concentrate on questions of fact. Fact will come in what is the facts of the case. There it will be asked. So that is there. And I would say that you finish all the answers, attempt all of them. There is no negative marking here. It's not an objective exam in which you have a 0.25 or a 0.5 marking or an examiner is judging you. If there is a certain weak question which is very difficult for you to answer, which I also did, there was a difficult question, perhaps of an election petition or a genealogy question, which was question number 3. I attempted it in the end. So this is how it can be done. And so I'll just take you to the question paper. If sir may allow, I'll just take 4-5 minutes, Somani ji, if that is fine. Yes, and I'll just run them through. So once you make that sentence, it should convey just one idea only. And sometimes there is certain kind of a petition. I'll just show you with these, because these were all 5 different questions which came in paper. No 2 were asked similarly.
ये मीटिंग ऊपर होने वाली है क्या? अच्छा.
All right. So this question number 1 in the last paper was a election petition. So sometimes one may not be knowing the format because it is little tough and out of the league. But appendix was the representation of the people Act 1951, and the election symbol order was also given. So it becomes easy for us that the law is already given, facts we understand. Now we have to apply our mind.
Just hold a minute. Just hold on a minute. कहाँ गया? हाँ, yes. Yes, Subiji, can you mute? Can you mute? Check. Just hold a minute. Yes, Subiji.
All right. So what happens is that once you get those 30 minutes, I would just suggest, because you just have now 1 month to go for this paper number 2 drafting, that one is that this is very different from the pleadings or the drafting which we do in the court of law. Here they are only interested in understanding what is the heading. You know that it's an original jurisdiction or an appellate or it's a writ petition. what is the Supreme Court rule, what is the particular article. Now, sometimes there is a case study, it's a trick that they ask, it is pertaining to 2014. And 15, they go, the impugned order of the Honorable High Court, the particular jurisdictional High Court, is of May 2015. Now, you have to appeal to the Supreme Court. Now, for that, writing that, you write a civil appeal dash of 2015. Don't write of 2024, because you are filing it in 2015, right? Now, so that is the format, basic format, and then your content is very important. They are not interested in knowing what is the index or what is an affidavit. It obviously depends upon the instructions of the question paper. In our times, it was clearly given, but it's not the general thing as is done, which are generally the clerks do. But what is the content, that is more important. That is what they are interested in actually. So the question number 1 was draft an appropriate petition on behalf of the election petitioner. So that means that it is a question of an election petition. This was question number 1 which came, and the law, the act and the order was annexed to it. So for our understanding. Now see, in those 30 minutes which you get, you should try it at your home also. I would suggest keep 2.5 hours for the exam, attempting each of the answer in half hour, 30 minutes. And before that, take those 30 minutes, before that 2.5 hours, those 30 minutes to read the question paper at home and try to see if you are able to amalgamate all the 5 questions or 3 or 2. Now, in your examination hall, if you're comfortable to understand all the 5 questions in those 30 minutes, in the starting 30 minutes, it's good. If not, again, good. Don't try to read the entire question paper and not understand even a single question, meaning thereby that you may understand 2 questions, giving 15 minutes each in those 30-minute slot, so that you are well aware of what these 2 questions are and read the other ones after those 30 minutes. So that 30 minutes should not get useless that you read the entire question paper and don't you understand anything, because it's a difficult. This reading is hardcore. It is difficult. Now, question number 2 was a review petition, which I just want to bring forth. It's very critical. Apart from your technical skill of facts, legal, here is where, especially in the review petition, your soft skills come into play. You cannot write that we are prejudiced with the court's order, did not appreciate the facts, because you are into review or you are into a curative. Curative or a review is before the same bench. You have to be very polite. You may say that the honorable court, it might have escaped the attention of the honorable bench. Maybe there was an inadvertent error that crept in, or this is the situation that may consider this appropriate remedy or alternative strategy, because you are at the highest constitutional court and you are into review. So now here the kind of tone and the language becomes very important. So this was actually a question on review which came, and I would suggest that certain things are peculiar also. You must write that the certificate from the AOR for this review is attached, which is a mandatory condition as per the Supreme Court rules also. Now, third question was a genealogy question, which was quite a tough question. It was a family tree in which there was one person. And if my friends are having this question paper, could be downloaded from the Supreme Court website also. If we clearly see up till para 6 of this question paper were the facts. Now, para 7 says, Asha only examined herself and Babita as PWs, which means the legality is coming into play, and Asha died and the Babita was substituted as the plaintiff in the title suit. So the legality is coming into play. And in para 11, it says the Honorable High Court held as under. So this order, the operative order, was the impugned order which came into play, which is now assigned before the Honorable Supreme Court. So this can be known when we read the question paper. And then there was question 4, which was a transfer petition. Now, here your creativity also comes into play. There was this journalist who was getting aggrieved with certain kind of political vendetta there, and he wanted that the petition should be transferred because there was certain collusion going on. Now, you have to write, because it is not written, you have to write what are the compelling grounds why the transfer petition should stand in the first place. Maybe he's the sole breadwinner in the family, he is recently married, or he's a small child who is an infant, and it is easier for him to commute here, and he has a long standing and he has other works also to do, maybe on the field. So these kind of things, your creativity will come into play. And similarly, question 5 was a PIL in which the name of the association was not given. So it was a PIL which has to be filed, but it can be filed through some welfare association. So you write the name of that association, you write certain ministry, which is the corresponding ministry of the government of India, or it was an Indian Medical Association, which was also respondent here. And then when you file it by a secretary or a chairman of that association, you also file an annexure to that effect, which is a resolution or an authority letter. So this is where the question paper will be silent, but your creativity, your understanding, and your practice will come very handy here. So these are certain tips, and I think would come handy, which would be a little unique, and which I also applied in my exam. And it was a tough exam, as to be very honest, which I did felt, and I could really see when Somani ji, when people came in the third paper, it was almost 50%, because the paper 2 was really technical. But that is how it is, and it should be like that, because the quality AORs should be coming in. But
yes.
certain practice is required in this paper, and then one, I think, should be, I'm confident, should be able to sail it through.
Very nicely you explain everything with your meritorious thought.
Thank you, sir.
मैं कुछ ऐड करना चाहूंगा दर्शक के लिए कि अभी कम से कम मैं 2018 से सुप्रीम कोर्ट आया हुआ हूं. अभी तक मैंने 400-500 से ज्यादा केसेस फाइल किए, आर्ग्यू किए, मोर देन 1500 मोर देन अपीयरेंस आई हैव गिवन. तो प्रैक्टिकली मुझे ये बात पता चली है कि क्वेश्चन ऑफ लॉज एंड ग्राउंड्स आर डिफरेंट. सम क्वेश्चन ऑफ लॉज कैन बी अ ग्राउंड, बट नॉट ऑल क्वेश्चन ऑफ. लोग क्या करते हैं, क्वेश्चन ऑफ लॉज को खाली वेदर निकाल के और उसको बिकॉज टैग लगा के और उसका इंट्रोडक्टरी इसको क्वेश्चन का जो फॉर्मेट है वो चेंज करके उसको ग्राउंड बना लेता है. तो ऐसा अगर करते हैं तो वो समझ जाते हैं एग्जामिनर की नहीं आ रहा है, आपको ग्राउंड क्या होता है ये पता नहीं है. क्वेश्चन ऑफ लॉज अलग होते हैं, ग्राउंड्स अलग होते हैं. एसएलपी के ऊपर क्वेश्चन आना ही आना है, रिट पिटिशन के ऊपर क्वेश्चन आना ही आना है, काउंटर एक्ट के ऊपर क्वेश्चन आना ही आना है, ये याद रखना है. और इसमें सबसे इंपॉर्टेंट है कि आपका राइटिंग स्पीड. अगर रोज 1.5-2 घंटा आप लिखने की प्रैक्टिस अगर आखिरी 30 दिनों में करते हैं, कि जो हमारी छूट गई है, हमको टाइपिंग का प्रैक्टिस है. मैं तो रिकमेंड करूंगा हमारे रजिस्ट्री को जो ये एग्जाम कंडक्ट करते हैं कि भाई ये एग्जामिनेशन के लिए इंस्टेड ऑफ पेपर आप खाली कंप्यूटर अलाउड कर दो या लैपटॉप अलाउड कर दो. कम से कम वो कॉस्ट टाइटल लिखने में जो समय जाता है ना, वो हमारा एग्जामिनर जो एग्जामिनर ही रहेगा वो उसको कट पेस्ट करके अगले क्वेश्चन को ले सकता है और थोड़ा स्पीड बढ़ा सकता है. लेकिन यहाँ पे अभी तो पेपर पे ही है, तो देयर इज नो अल्टरनेटिव. तो थोड़ा लिखने का प्रैक्टिस करो अच्छा. और हमारा जो ड्राफ्टिंग का पेपर है, जो एकता वर्मा ने मुझे असिस्ट किया है ये कंपाइल करने के लिए, ये ड्राफ्टिंग के पेपर में हमारा जो बुक्स है जो अमेजोन के ऊपर या फ्लिपकार्ट के ऊपर अवेलेबल है, ये साल ही है. आपके समय में ये आपको मिला नहीं क्योंकि पब्लिश नहीं हुआ था, अभी हमने पब्लिश किया है. तो इसमें ऑल टाइप ऑफ ड्राफ्ट हमने कवर किए हैं. जितने ड्राफ्ट सुप्रीम कोर्ट में यूज होते हैं सभी ड्राफ्ट हमने कवर किए हुए हैं. तो वो ड्राफ्ट के अनुसार आप प्रॉपरली अपना ड्राफ्टिंग कीजिए. और फर्स्ट एटम, सेकंड एटम, ऐसा कोई प्रॉब्लम नहीं रहता है. काफी लोग हैं, जैसा मेरा जूनियर है निशांत वर्मा फर्स्ट एटम में क्लियर हो गया था एओआर एग्जामिनेशन. तो ऐसा क्लियर फर्स्ट एटम में भी क्लियर हो सकते हैं, या 2-3 एटम भी लगते हैं तो कोई प्रॉब्लम नहीं. एओआर बनना इंपॉर्टेंट है. हाउ मच परसेंटेज यू आर टेकिंग दिस एग्जामिनेशन ये मायने नहीं रखता है, लेकिन आप एक बार क्लियर हो जाते हैं एग्जामिनेशन, एक कॉन्फिडेंस लेवल बढ़ता है. और जो यंग लॉयर रहता है, यंग लॉयर अगर एओआर बन जाते हैं ना जल्दी, तो उनका स्टैंड सुप्रीम कोर्ट में होना थोड़ा फर्म अच्छा होता है. तो वो हिसाब से, सो दिस इज दी वे ऑफ राइटिंग द पेपर ऑफ इन ड्राफ्टिंग पेपर. तो बहुत अच्छा एक्सप्लेन किया सुमित जी. तो और सुमित जी, मैं इंसॉल्वेंसी प्रोफेशनल हूँ. तो ये इंसॉल्वेंसी का एग्जामिनेशन मैंने 8 बार फेल हुआ है उसमें. ये लोग 4 बार में क्लियर हो जाते हैं. हम लॉयर लोग हैं ना, तो लॉयर लोगों को मैं तो 8 बार दिया हूँ. इसलिए मैं लोगों को बताता हूँ कि कंसीडर, कि भी आप ऐसा कंसीडर कर सकते हैं, आप बुद्धू आदमी है, सोमानी 8 बार एग्जाम देना पड़ा, बराबर है. और ऐसा भी कंसीडर कर सकते हैं कि ये सोमानी ज्यादा होशियार इंसॉल्वेंसी में कि 8 बार इसकी रिवीजन हुई है सब लॉ को. तो ऐसा है. तो अभी
I remember our times we were struggling to get a good book on drafting, so this I think book will come very handy, because सब drafts एक जगह आ जाए ना compilation, because है तो वो set 15-20 हैं, लेकिन उनमें से कोई भी आ जाता है, and sometimes there is no choice also, so then it becomes easy. राइटिंग तो वहाँ क्वेश्चन पेपर में ही देख के करना है कैसे होगा, बट फॉर्मेट्स अंडरस्टैंडिंग प्रैक्टिस।
मेनली क्या होता है 131 का जो ड्राफ्ट रहता है ना, वही आदत नहीं रहती है हमको प्रैक्टिस में, क्योंकि 131 हमारे पास आता ही नहीं है। क्योंकि एक राज्य से दूसरे राज्य में जो झगड़ा चल रहा है वो सुप्रीम कोर्ट में आता है ओरिजिनल जुडिक्शन में अंडर आर्टिकल 131। ओके, या टू स्टेट एंड सेंट्रल है, इसका भी आएगा, या वन स्टेट सेंट्रल है। तो ये, तो इसके जो है एडवोकेट जनरल रहते हैं, उनके सॉलिसिटर जनरल रहते हैं हमारे, या एडवोकेट जनरल, इनकी टीम ही ड्राफ्ट करती है। ये कॉमन लॉयर के पास हमारे पास 131 का ड्राफ्ट कभी प्रैक्टिस में आता ही नहीं है, इसलिए ऐसे कभी ड्राफ्टिंग पूछ लेते हैं ना तो गड़बड़ होता है। इसलिए ऑल शुड हैव द ड्राफ्टिंग फॉर्मेट, तो ये हमने प्रिकॉशन रखा है। और सुमित जी ऐसा मत समझना कि हमने वर्चुअल लेके हमारा रिस्पॉन्सिबिलिटी खत्म कर दिया, नहीं। हम और आज जो 5 AOR का हम सम्मान कर रहे हैं, सब हम साथ में खाना खाएंगे, हम सुप्रीम कोर्ट पे कैंटीन में खाना भी खाएंगे, उसका फोटो निकाल के हम शेयर भी करेंगे हमारे सब पार्टिसिपेंट को, और एक तरह से सम्मान हम पर्सनली भी आपका फिजिकल मिलके करेंगे। थैंक यू
सो वेरी मच।
फॉर ज्वाइनिंग।